Wait, please, Lordship. Lord, item number 5, 6, and 7. Lord, I need to file a reply affidavit. Government has filed a affidavit.
5, 6, and 7.
5, 6, and 7, yes.
Need to file
Affidavit, reply counter. Madam.
counter.
So 4 weeks time maybe give plan to. After vacation, let it come after vacation.
Otherwise, the state government has already filed their
Yes.
in opposition.
I have informed the senior government advocate.
Administrative departing, same order, we learn it, counsel for the petition, and also heard Mr. S. Tapin, the learned senior advocate for the state respondent. It is submitted by Mr. Patton that in all three, he submitted that he wants to file the written, the affidavit in counter affidavit against the affidavit in opposition filed by the government. Accordingly, it takes some more time, enabling him to file the affidavits. Prayer allowed. And the senior government advocate, Mr. S. Tapin, there is no objection. List accordingly, how many weeks you need?
Can be listed after puja break. After summer break.
After this, the matters after summer. You also appearing in this case, no?
Obliged.
May I please, Your Lordship? I beg to mention item 13 and 14. Lordship, in this case, I was supposed to file affidavit in reply, which I could not. I have spoken to the other side also. Can it be taken up on 12 this next week? I'll file before that.
Madam, this is urgent matter. Next date, endeavor shall be made to dispose of the matter and last opportunity.
He is insisting on 12th.
On 12th.
We do.
This
That's
may,
fine. That's fine.
this may be last opportunity.
No, but without further adjournment.
Yes.
My lord can only make the observation that without further adjournment, endeavor shall be made to dispose of the matter. Well, I am representing intervener number 5.
Yes, you are intervener, yes.
Yes.
You have already filed the amended cost title order.
Yes.
I have seen the
My lord, my name is not reflected. Yesterday I was.
Oh, yes. Your name is not written.
Yes, registry may be directed to reflect my name and associates.
You want to, you're for the petitioner now, intervener, is it?
Now intervener will be
Dick, that's it.
respondents only. 30,
Hard MS and Dangin, the learned counsel for the petition.
170.
And also hard Mr. Jeter, the learned. You are Mr.
Jitara,
Jitara.
standing counsel.
Standing counsel. RBW, and also hard Mr. Titara, the learned counsel appearing for the intervener. It is submitted by Ms. Tangen that due to some due to some inconvenience, she could not file the affidavit in reply and needs some more time to file the same. In this context, Mr. Tarak, the learned standing counsels RWD submitted that this may be considered the last chance for the petitioner to file their affidavit in reply. Full stop. Prayer allowed. Will reply full stop. Let the matter be accordingly listed on 12/6/2024, and endeavor shall be made to dispose of the matter the day itself. Further, the arrest is ever directed to reflect the name of Mr. T.T. Tara as a who appeared as an intervener in the cause list.
Lordship,
Yes.
interim orders may be continued.
Interim orders, we continue to make statements.
Obliged.
My lord, kind indulgence to item 16.
Yes,
And,
it is item 16.
My lord, let me seek instruction from my client because whether there is any more live issues. So he has become MLA, then he might be settling his things in a different manner. My lord, list it after the reopening of summer vacation.
Item number 16, had Mr. T.T. Tara, the learned counsel for the petition, and also had Mr. S. Tropin, the learned senior advocate. It is submitted by Mr. Tara that he needs some more time to take instructions as he is not aware about any new development. If there is any new development. Full stop. Let the matter be after vacation.
After,
Let the matter be listed accordingly after the vacation.
grateful.
May I, Lordship, I beg to mention on unlisted matter for withdrawal, Lordship.
It will come tomorrow or today.
Today itself, Lordship.
Today you want.
Obliged.
My lord, I mentioned item number 23 for adjournment. The learned counsel is on leave and we already submit a leave application, but it's not reflect.
And this council, Mr. Sonar, our Sonar,
Yes, ours on.
he is not available. Madam is so-and-so appearing on behalf of Mr. R. Sonar and submitted that he is not available in the station to argue the matter and accordingly paid the adjournment. Standing Council of Horticulture is also there. Have you informed anything? Anyone?
No, your honor.
My lordship, I beg to mention item number 24. And for the petitioner.
Yes.
Lordship, I beg to mention item number 24. And for the petitioner, due to some personal difficulty, we cannot prepare for this matter. We have taken consent from the other party also. Kindly
From the
this
other side?
matter.
You have taken consent of the other
Yes, my
side.
lord. Yes, my lord.
You are for the petition.
Yes, my lord.
With the consent of the other side, the learned counsel for the petition, paid for an adjournment, submitting that he is not in a position to argue with the matter due to some personal inconvenience. And let the matter be accordingly listed. This is out of
weeks, madam.
2018 matter.
Yes, my
2
lord.
weeks you need.
3 weeks, my lord.
3 weeks, no, 2 weeks will. It will be listed after 2 weeks.
Okay,
As on a date to be fixed by the registry.
obliged.
May I please, Lordship? Back to mention item number 4. Lordship, this matter kindly be fixed on 17th July. And for the petitioner.
Why? Is there any reason?
17th June.
Huh?
Lordship.
Why you need an adjournment?
Lordship, the conducting council, Mr. E. Tatak is not in good health.
I am for the respondent.
You're for the response. You're Mr. N. Khera,
As they.
as Dave. For the private respondent.
Yeah, no, Your Lordship, I am for the corporation.
Huh?
Pasigat Smart City.
Pasika?
Smart City Corporation.
Number 4, item number 4.
I'm colleague of N. Khera. Respondent number 3.
Pasika Smart City
Yes.
Development. For 1 and 2.
Yes.
For 1 and 2. Number 4, heard Mr. So-and-so, the learned counsel appearing on behalf of Mr. E. Tatak, the learned and his counsel for the petition. And also heard Mr. You are Mr.
As they.
S. Dave appearing on behalf of the respondent number 3. And also heard Ms. So-and-so, the learned government advocate appearing for the respondent number 1 and 2. It is submitted by Mr. So-and-so that due to personal inconvenience, Mr. Tatak is not in a position to argue to appear in this case today. And accordingly paid for the adjournment. You want any fixed date on 17th,
17th July.
17th of July,
Yes, Lordship. Since the
after
respondent number.
vacation,
Yes, Lordship. Since respondent number.
We are
3 is from
outstation.
Out of station.
outstation. Okay. Fix it on 17th of July, 17/7.
Hello.
Give me your Lordship.
Yeah, Lordship. Lordship, I beg to mention item number 15 and 25 on behalf of Deep Angan.
15 and
25. Lordship, conducting council, Deep Angan is out of station. We have taken consent from opposite side.
same order queriable, Mr. Deepan. Out of station with the consent of the other side. Adjournment. When do you want?
2 weeks, Lordship.
Body matters? Body matters after 2 weeks?
Yes, Lordship.
Yes, body matters after 2 weeks.
Right. So
Lordship, I beg to mention item number 26 on behalf of S. Roy.
On behalf of?
S. Roy. Lordship, his leading counsel is from Delhi, so he is unable to attend the matter. So the matter may be fixed on last week of this month.
You want any fixed date as because he is from outstation, that's why I'm asking.
Yes.
Want any fixed date? Because
Uh,
it is a matter of,
Pardon?
you want any fixed date?
Yes,
Do you want any fixed date?
last week of this month.
Last week of this
This
month?
month, yeah.
Same কাৰণ এষ্ট্ৰই নাহিব পৰা বুলি ক'ব এজন কৰি দিব last week of this month. (27 or 28?
Okay.
28.
My lord, I like to mention item number 8 on behalf of Council M. Nibo. I like to mention item number 8 on behalf of M. Nibo Council. Ma'am, my lord, it may be listed after 3 weeks.
On behalf of who?
M. Nibo.
He's not available?
Huh?
He is not present today,
Ma'am, my lord, he is out of station.
out of station. And
my
Mr.
lord.
N. Nibo.
M. Nibo.
How is the student check order? After you want, after 3 weeks,
Yes, yes, my lord.
list accordingly after 3 weeks.
My lord, I would like to mention item number 2021, my lord. Today I am going to file affidavit, my lord, in all case manner. My lord, I am appearing for response number 2. I also taken consent of the petitioner, my lord.
20 and 21.
22 and 21. 20,
So
21.
you are appearing for the respondent now.
Yes, my lord. Respondent number 2.
Respondent number?
2, my lord.
So why you need adjournment?
Yes, my lord. Today I am going to file affidavit, my lord.
Affidavit.
Yes, my lord. Matter may be next, fixed for next week, my lord.
You have taken consent of the
Yes, madam.
other side, this
Yes,
is
madam.
petitioner.
Yes, madam.
With the consent of the other side, the newly engaged counsel for the respondent number 2, Mr. Your good name?
Pramod Kumar Gok.
Pramod Kumar,
Go.
for an adjournment, submitting that he is going to file the affidavit in opposition in both the matters. Affidavit in opposition accordingly needs some more time to file the same. MS so and so. Yeah.
No, Your Lordship, I'm not in.
You are not paying access.
Okay.
May I please, Your
After
Lordship?
2 weeks.
May I please, Your Lordship? Your Lordship, I beg to mention item number 3 of admission column, Your Lordship, on behalf of Miss G. Ite, the additional senior government advocate, Your Lordship.
On behalf of
Miss G. Ite. G. Ite.
GAT.
Yes, Your Lordship. This item, Your Lordship, kindly fix this item on 12 of this month, Your Lordship. As she had some difficulty today, Your Lordship.
Have you informed the petitioner side
Yes, Your Lordship. I have taken the consent also.
with the consent of the other side? The learned, she's a government advocate now.
Yes, for official respondent, 1, 2, and 3.
The MS so and so appearing on behalf of MSG this the government advocate paid for an adjournment. She is not available today.
Yes, Your Lordship. She had some
Did-
personal difficulty.
Yes, due to some personal difficulty, she could not appear before the learned court, before the court. List accordingly on 12/6.
Yes, Your Lordship.
List the matter accordingly on 12/6.
Obliged.
I am appearing through video conference, Lordship. May I?
Yes,
Lordship, this is a GST matter. Similar matters to the challenge of the notifications are pending in the principal bench as well as in Itanagar bench, Lordship. There are 2 notifications were issued for extension of time limit for assessment for the period 2018-19, Lordship. If your Lordship may peruse paragraph 13, page 12 of my petition, Lordship. paragraph 13, page 12, Lordship.
Yes.
Lordship will peruse that two notifications have been issued by the GST authorities, which are 31/3 to 2023 and 28/12 2023. Based on these two notifications, they have extended the time limit of assessment under section 73, Lordship. Lordship, the time limit for assessment is 3 years from the date of filing of annual return, which is in the later part of paragraph 13 on the next page, Lordship. Which last part of paragraph 13 says the due date for passing order under section 7310 of CGST Act was 31/12/2023, and the due date to issue the show cause notice under section 73 was 30/9/2023. So in my case, Lordship, the show cause notice was issued after 30/9/2023 based on the extension given by the notification. So in this case, Lordship, I am challenging the notifications as well as the entire proceedings, which culminated into order dated 22/4/2024, Lordship. I have furnished a similar copy of order which is pending before Itanagar bench, Lordship. If your Lordship peruses that order, my local associate has furnished a copy of judgment, Lordship, interim order.
Who is
I can.
Who is your
It
associate?
is Dabjum Riba. I can point out the case number, Lordship. A similar order I found, WPC 163/2024, Lordship.
WPC?
163 2024, Lordship. A to Z Infra Engineering.
Someone has submitted now. Yeah, you have submitted. Okay.
Yes, Lordship. If your Lordship peruses this order that dated 10/4/24, the challenge to the notifications date will be, Lordship, 31/3/23, as mentioned in paragraph 13, and 28/12/23. Two notifications have been challenged, Lordship. And the order date, Lordship, will be 22/4/2024. And there is the mention of demand in this order, Lordship. The amount of demand,
The
Lordship, can
order,
find it.
you have placed annexed your order in which page?
It
Page number?
is page 64. Page 64, Lordship, will find the quantum of demand, Lordship. The order part, operative part, page 64, Lordship.
Yes, I've seen.
That will be completely similar matter, Lordship. That is my humble submission. In this matter also, interim protection was granted, Lordship. The same order will suffice, Lordship.
Yes, Mr. Your opinion.
Malad, I may be allowed to take instruction from the respondent department, Malad.
And
Now
in
the
regard,
subsequent, what subsequent development has been took place in the impugn order. It was passed long days back, man.
The impugn order is 22/4/24, Lordship. April 22.
Tomorrow, madam. I'll take instruction from.
Lordship can issue notices with similar order, Lordship, because it is pending already before this bench.
now he is insisting for any interim prayer.
Malad.
Do you
For
have anything
interim,
to say?
matter may be
Yes.
listed for tomorrow, Malad. I'll take instruction because whether this is one of the difficulties, I have not gone through the Malad. Just now I have received a copy of this writ petition, Malad. And it seems that it has been filed,
So it can be listed tomorrow?
Malad.
Otherwise, notice since you are appearing for one
All respondents.
on to 1 to 6, all respondents. Your good name?
D.
Your good
Sharaf,
name?
Lordship.
B. Sharaf? Heard Mr. B. Sharaf, the learned
Lordship.
counsel for the petition, and also heard Mr. So the learned. You are DSGI. DSGI, I'm part of for the respond number 1 to 6. This is an application under Article 226 of the Constitution, India, for issuance of a writ of certiorari or a writ of nature of mandamus or any other appropriate writ comma, direction or order, which has been filed challenging the impugn order dated 22/4/2024 passed by respondent number 3, as well as the impugn show cause notice dated 21/12/2023 issued by respondent number 3. Respondent number 3, both of which purportedly derive authority under the impugn notification number 09/2023 CT dated 31/3/2023 and impugn notification number 56/2023 CT dated 28/12/2023 issued by respondent number 5 and 6. As the learned DSGI has already appeared for all the respondents, no formal notice is required to be furnished. However, no A to D. Okay. Further, Mr. Kato, the learned M. Kato, the learned DSGI submitted that he will take instructions from his client and accordingly fix the matter to him. Full stop. Prayer allowed. We will let the matter be accordingly listed. On tomorrow, we are listing the matter because he wants to take some instructions from the authority concerned.
Obliging.
So we will listing it tomorrow. Okay, list tomorrow.
Lordship.
Deeply obliged, ma'am.
Deeply obliged.
Madam, here I am appearing on behalf of all respondent number 1 to 7, madam. Madam, my friend is madam, I may be given some more time to file a affidavit, madam. Whether this is madam regarding madam whether land has to be regularized or not, madam, it is under the position of the Union of India, madam. So therefore, madam, whether that they wanted to occupy continuously on the present status or they wanted to acquire it permanently, madam. That is the only things issue, the issue, madam, involved. So 4 weeks time may be given, madam. It is not that much, madam. There is no urgency also, madam.
Madam.
Heard Mr. Gopada, the learned counsel for the petition, and also heard Mr. M. Kato, the learned DSGI, appearing on behalf of the respondent. Land management is also appearing by, you are appearing for
The
the,
state has filed their affidavit.
Huh?
The state is.
they have already filed.
Yes,
You have
9 and 10.
you have already filed
Yes.
your
But-
affidavit.
but the main is the Union of India.
Yes,
Respondent
Hard,
respondent
number
number 1 to 7, madam.
you are for 1,
1 to 7, madam. 1, 2, 3, 4, 5, 6, 7, 7, and 7, madam.
1, 2, 3, 4, 5, 6, 7.
Madam.
Okay, you are for 9 and 10.
Yes, for DC and IC.
Okay. So and so appearing on behalf of the respondent, state respondent 1, 2, 3, 4, 5, 6, and 7. 7, 8 also. No? You are
No,
appearing
madam.
for 8.
I'm for 1 to 7, madam.
1 to 7. Who is appearing for 8?
8, madam.
Or land management? Yeah, they have already filed their affidavit.
The land
Sitting
management, yes, the land management.
No. Land management has already filed their affidavit or not yet?
Yes, madam. 9 and 10 is fine.
No, 9 and 10 they have filed. For 9 and 10, most probably they have filed. I'm for 7. Okay, sorry, 8.
8 is the land management department.
8 is the land management department.
But I think that the affidavit of 9 and 10 will suffice now.
Okay.
So it is a secretary land management. So the LRSO is filed on behalf of the Deputy Commission.
Stop. Appearance to answer, pray for some more time to file the affidavit in opposition. And the learned government advocate, MS so and so appearing on. You are appearing for or you are appearing this case
Yes, Your Lordship.
on behalf of
For state respondent.
state respondent. Government advocate on behalf of state respondent number 9 and 10. And it is seen that the respondent number 9 and 10 had already filed their affidavit in opposition. However, considering the submission made by the learned DSGI Mr. M. Kato. How many weeks you need?
4 weeks time.
4 weeks. 4 weeks time may be allowed to file, enabling him to file the written affidavit in opposition on behalf of respondent number 1 to 7. List the matter accordingly after 4 weeks.
Development.
Nine. Yes.
Your Lordship, we have received copy of affidavit just a while ago from respondent number 2, 3, 4, and 5. So we may given some more time to go through it.
2, 3, 4, and 5. And what
Yes.
about 1? 1 is who is 1?
Lordship. No, Lordship, it will cover.
Yes.
The affidavit filed by 2, 3, 4 will cover. Because it's about
two-
compensatory appointment, Lordship. And
2, 3, 4, and 5 will cover you also.
Lordship. Because we have already initiated the process, therefore it will cover.
You are MS?
T. Choten.
T.
Choten.
Hard MST Toden, Deland counsel for the petition. And also heard Mr. M. Miriku,
Ayriram.
Eh?
Ayriram.
hired Ikram for the learned comment advocate. From the office note, it reveals that the respondent number 2, 3, 4, and 5 had already filed their affidavit in opposition. However, it is submitted by the learned government advocate, Mr. Ikram, that the affidavit in opposition filed by respondent number 2, 3, 4, and 5 will also will be relied by them also, relied by the respondent number 1. In this context, Ms. MS so-and-so has submitted that you want to file an affidavit in the
Yes,
reply.
Your Lordship.
Want to file the affidavit in reply against the affidavit in opposition filed by respondent number 2, 3, 4, and 5. How many weeks you need?
2 weeks, Your Lordship.
List the matter accordingly after 2 weeks, enabling the petitioner to file their affidavit in reply.
Obliged.
Item number 10.
My Lord, I'm appearing for the private respondent number 5. I have raised the question of maintainability, which is to be taken up today. But it is purely on technical and law points. Just
It
Will
was
not take
earlier
much
part
time.
heard or what you said?
not part heard.
Okay.
My lord, in view of the order passed by the Honorable Court, we have taken steps upon to the Secretary Land Management, my lord. And the extent of the Secretary Land Management is required, my lord. That's because the
My Lord, it is not required because
my lord, the copy,
unless the question of materiality is answered,
my lord, that will be a different thing,
In one order was passed in that regard.
my lord.
but it is only because the civil appeal is pending and it's only
My lord, maintainability will also be decided as, my lord, once the affidavit is come by the state respondent, my lord. Now, my lord, the irony is, my lord, the state respondent is not appearing before this honorable court. Wherein, my lord, what happened? There is a prescribed permit, duly, my lord, prescribed by the state government for issuance of the LPC, my lord.
And now, my lord, the LPC, which says, my lord, in the prescribed format, which has not been stated at all, which is not required to be complied with, which is not required to be followed, my lord, that has been imposed upon me. You have not complied the requirement, which has not at all been specified in the format. Because of that reason, non-compliance of the, my lord, the other things, you have not followed, you have not done these things, therefore your LPC is cancelled. That is the whole issues, my lord.
My lord, since,
Therefore, my lord,
since I am the one who has raised the question of mentality, I may be allowed to make my submissions first. Then,
No, it's okay, but his submission is that the land management has already been implemented as a party, not yet.
yes, my lord,
it's not
respondent
required.
number
The
one.
respondent number 3 and 4, the deputy commissioner and additional deputy commissioner, they have filed their affidavit.
Their state is different matter. They are district administration matter.
I will,
State respondent is very much requirement. It's because my lord,
I will satisfy your lordship
I'm just
that
asking you.
there is a
whether-
serious violation of the guidelines. But it is not the counsel for the state government who has pleaded that copy has not been furnished to us, but it is the petitioner only to delay this case.
no, my lord.
But
On the last occasion, my lord-
as per order dated 13/5/2024,
My lord.
on that day, Mr. Kamdok, the Land Standing Council of Land Management was present.
Yes.
Correct, my lord.
But he is not the party. I mean, the management is not the party.
Respondent number one, my lord.
Oh, respondent number 1. Acha.
My lord, he is the, my lord, the government and head of the, my lord, the government of this land management department. And the
I think that
affidavit
is-
on the part of the,
That
my
is
lord,
being
state
represented by
respondent-
Mr. Tapin.
Respondent is
Number
very
one.
much required, my lord.
What, yes, Mr. Tapin, what do you want to say? Like he is insisting that
state-
the land management, the council for the land management is also required.
Respondent
Can we
number 1
wait
is
for them then wait for him then? Yes, you are for respondent number 3 and 4.
what about 1?
1 and 2.
Land management department.
Yes, Mr. Kamdok.
Kamduk was present. So copy was served to him.
And my lord, another
And
thing.
in all the earlier occasion also, Mr. Kamduk was present. And it is only for hearing the question of maintainability. My lord, I'll just,
No, Dave, we can do one thing. He is present today?
No, my lord.
He is not present.
Not
today?
present today. Even now, my lord, in fact, I personally approached before the Learned Secretary for clarifications of entire things, my lord. And he was of the view then, yes, affidavit will be filed shortly. But I'm surprised, my lord, today, as of now, my lord, no affidavit has come forward. So
Look,
therefore, my lord, in one more, my lord, the opportunity may be given to the Secretary Land Management. If, my lord, if at all not interested to file then my affidavit, my lord, then the matter could have been, my lord, the different position, my lord.
Look,
And
it is-
my lord, another thing, my lord, I'm sorry, my lord, again, my lord, I'll file objections to this maintainability also, my lord. There's so many things has been raised.
no, my
So,
lord.
maintainability issue they have already raised in their.
Yes.
They have filed their affidavit in opposition with.
My lord, reply to this affidavit, my lord, affidavit.
Have you filed your reply? Not yet.
That will
My lord.
come,
Not yet. You have not yet filed your
No, my
reply.
my lord. That will come after that is the next stage. First is the question of maintainability has
Exactly,
to
my
be
lord.
decided.
I may be allowed to file objections to the maintainability.
No, my lord, it is not, that is not the system. When question of maintainability has been,
But the question is that once you have raised the issue of maintainability, so obviously they oral submission will also do that is I'm
My
not
lord,
on that.
in my objection petition, I have not explained as to under what ground the question of maintainability has been taken off. So therefore, they do not know what ground I will urge. And how can they say that they want to file?
It will be surprising for him then. What ground you will urge or
Yes.
what ground you are going to.
I have raised the
issue.
question, I have raised the question of maintainability. I will urge
Now
my
you are saying that
grounds.
the issue of maintainability is here because it is not,
Yes.
as per it's not maintainable. So in that case, if you have filed your affidavit and taken the plea that it's not maintainable. Now, if you are ready for submission, oral submission, I'm here to hear the matter.
No, my lord, at least, my lord, that one opportunity may be given, my lord. Otherwise, my lord, it has to be heard. Finally, it has to be decided, my lord. That we don't have any, my lord, my lord, the only thing is that we have
okay,
another
that's-
time to, my lord, my lord, the proper adjudications of the case by way of filing affidavit, my lord. That is the only whole, my lord, my fear. And I just wanted to file, my lord, the reply to the affidavit filed by the, my lord, the private respondents here.
But now he's saying that the issue of maintainability, he's not, most probably the grounds have not mentioned in their, in his affidavit in opposition
Yes.
regarding the maintainability.
Then,
And
my
it
lord,
was
the
fi-
question of, my lord, the maintainability to be heard does not arise, my lord, again.
Lord, it was filed on 21 November 2023.
That is not the issue. Should be.
Well, it will
Then-
be-
Now
then
you
in
are
that
saying
case-
that you have not.
My lord, specifically, if maintainability has not been raised at all in their affidavit, my lord, the question of, my lord,
No,
making
my lord.
hearing on the
It
maintainability
is,
does
it
not
is,
arise.
it is, the, your
It
lordship,
has to be, my lord,
this honorable court, on the last occasion also, and previous to that also, there is a specific judicial order that the question of maintainability shall be taken off.
Is there any order? No?
Yes. Your lordship's earlier order also, and then prior to that also.
I guess one order is there on 9/4 that
Yes.
the, for admission hearing and the maintainability or otherwise the matter shall be, it will
No,
be.
yes.
thereafter subsequent development, my lord, my lord, serve the copy to the state respondent, my lord. Last order.
How, why the petitioner is so interested when the council does not require, doesn't.
That is the whole, my
ask-
lord, reason. That is the whole reason we wanted to serve the copy to the state respondent personally, my lord.
What?
Why, my lord, the state respondent, being the, my lord, the head of the department, is not interested to file an application?
Unless the question of availability
No,
of
no, state has
guidelines.
not filed, not yet filed their affidavit in opposition.
Yes, my lord.
You have not yet filed. Oh, you have.
State,
already
state respondent, state respondent.
State filed.
Land management department.
Land
My lord,
Why the petitioner is so interested?
my lord, land management department.
He is asking why you after land management.
My lord, is because he is the head of the land management department, my lord.
That
Who
is for the
prescribe, my lord, the
government
land,
side to decide.
land, my lord, what happened? Land are being allotted to the individual or the government or the any other organization through, my lord, the secretary land management, my lord. Secretary land management is the head of the department.
no,
the
my
entire
lord, no.
land management department, my lord, my lord, the prescribed, my lord, the format, everything, my lord, even it has to be approved by the secretary land management.
My lord,
My lord, cancellation cannot be done in that way, my lord, where the prescription, my lord, the prescribed format is not at all violated, my lord.
My lord, I will
I'll leave it
convince
to your
this
lordship,
honorable
my lord.
court
This is my lord.
that whatever the submissions made by my learned friend is misconceived.
No, we are just to hear the matter, but the question is if management is supposed to require the why don't you leave the matter on the next week candidate?
My lord.
Can it be? If they are interested to file an affidavit in opposition, it's okay. Otherwise, matter may be heard. All the maintainability issue will also come up at the stage of admission hearing itself. So 1 week will do.
My lord, for my lord, method on fixed date may be given when on which date, my lord, entire case will be disposed of.
No, but that but you want to file the any written I mean affidavit
My lord,
reply also.
that part I'll file, my lord.
So within 2-3 days you will be able to file.
My lord, a week time may be granted. My lord, week time may be granted. I'll file, my lord. I'll file to the definitely, my lord. I have to reply the queries. My lord,
Otherwise, he is ready for to argue the matter.
yes, my lord. A week
Mr.
time.
Kamduk may have some personal difficulty.
My
I don't
lord,
know.
week time will be my lord required. I'll
My lord,
file.
in that case, my lord, within a specific order, observation that whether respondent 1 and 2 files or not, or they do not file, the matter of the issue of maintainability shall be disposed of, and there shall not be any more adjournment, my lord.
My lord,
Let it come up
only-
on
my lord, my submission
12th,
is
13th.
not preliminary only, my lord. Entire matter may be disposed of.
No, my lord, no.
No preliminary is required, my lord. Matter may be disposed of, my lord. Once the affidavit is come and if they don't want to file, my lord, admittedly, my lord.
So in that case, why maintainability?
Yes,
The
my
entire
lord.
matter may be
The
heard.
entire matter may be disposed
Like
of.
in
Matter
that case,
preliminary
maintainability
objection
issue
is
will
not
also
required.
come. It
Yes,
may be
ma'am.
disposed of due to non-maintainability, or it may be
Correct,
entire
ma'am.
matter may be disposed of.
Preliminary is not required, my lord.
Specifically, maintainability issue may not be there, but you bring those issue.
But in that case, in any case, my lord, let there be a specific observation that this case will not be adjourned further.
No,
My lord,
that
my lord,
observation will be there.
the civil appeal which they have filed it's coming up very shortly. And this is sitting on the head of the court below. That there is something in the High Court, what will happen? And so there is no progress in that.
Okay. Okay, we'll pass a specific order in that case.
On 13, 12 or 13, Malad.
Heard Mr. M. Lato, the learned counsel for the petition, and also heard Mr. Departing. Oh no. Departing for the respondent number. For the private respondent number 5, and Mr. S. Tapin, the learned senior advocate, appearing on behalf of respondent number 2, 3. No? You are 3, 4. 3 and 4. However, Mr. D. Kamluk, the learned standing counsel for land management, is absent, and it is submitted by Mr. M. Kato that the presence of Mr. D. Kambuk, the learned standing counsel for the land management, is necessary, and he may be given one more chance to file the affidavit in opposition for the respondent number. No, you are for the affidavit in reply. He is for the affidavit in opposition. Affidavit in opposition to respondent number 1 and 2. Further, Mr. Kato, the learned counsel for the petitioner, submitted that he also wants to file the affidavit in reply against the affidavit in opposition filed by the private respondent number 5. Again, by the private respondent number 5. However, from the order dated 13/5/2024, it is seen that the learned counsel for the petitioner was already directed to furnish a copy of the petition to the Secretary Land Management Department, and the Land Management Department, that is the respondent number 1 and 2, was supposed to file their affidavit in opposition by today. Affidavit in opposition. However, Mr. Standing Counsel, Mr. Kamduk, is absent and has not represented the respondent number 1 and 2. Full stop. Next para. Mr. Patin submitted in this regard that the matter is urgent, and due to pendency of this matter before this court, the learned trial court below could not pass any order in which item, case number?
Civil appeal number 5 of 2023.
Civil appeal number
05.
05 to 2023.
Pending before the civil judge, senior division, UPR.
CA number 05/2023, pending before the civil judge, UPL, Papumpari district, Arunachal Pradesh. Next one, considering the interest submission made by the learned counsel for both sides, the respondent number 1 and 2 are hereby given one more chance to file their affidavit in opposition. One only. The respondent number 1 is given one more chance to file their affidavit in opposition, and Mr. M. Kato, the one and two. Learned counsel for the petitioner is also hereby directed to file their affidavit in reply, if any, on or before the next date of listing. List accordingly want 13th.
13.
Within observation that this case will not be adjourned further, whether they file it or not.
13 corridor. No, that is already I have. 13/6 corridor, and further the endeavor shall be made to dispose of the matter and to hear the issue of maintainability and other issues on the next date without giving further adjournment.
Malad, developers.
Here we were supposed to file our affidavit. Our affidavit is ready, but swearing is not yet been done.
My lord, may I draw your attention to the order of 22nd/4/24, which clearly says, in case counter affidavit are not filed by the state of Maharashtra as prayed for, this court will consider hearing on interim relief prayed by the petitioner. Subsequently, your lordship, on 20th/5/24, again, they had not filed, and again Honorable Court held prayer for interim shall be considered on the next fixed date, that is today. Lordship, I may be heard on that very briefly. I am not asking for stay, Your Lordship, because I do understand the work is of national importance, and a very simple intervention by Your Lordships will actually address this matter in full. And all that I'm asking for, before I go ahead, Your Lordship, I'll make a few explanation preliminary submissions. And Your Lordship, this is a matter regarding a power grid company's transmission line, installation of a transmission line. Now, Your Lordship, as per our constitution, property rights are not fundamental rights. As per 300A, the only right a property right owner has is that a property right cannot be alienated except by due process of law. Now, that is a very important point which has play here, Your Lordship. Why? Because the fundamental stand being taken by my learned colleagues representing the licensee, that is the power grid, and I'm sure the same point was orally mentioned in court also, is that this is not land acquisition. Your Ladyship, property rights are a spectrum of rights. Land acquisition is a procedure under a Land Acquisition Act. Now, here also, Your Ladyship, that state has said that the process of identifying beneficiaries is as similar to land acquisition. I'll take you to Your Ladyship to that. Now, Your Ladyship, what happens in this case is that there are two types of determination of land or reassignment of land that takes place. In this power transmission line, there is about 100 and something hectares of land which is being permanently taken up for setting up of the towers in totality. Each tower is about 25 meter by 25 meter. So the total is about 100 something hectares. Secondly, Your Lordship, the transmission line, the area it goes over also deteriorates in quality. So these are the two elements for which compensation is made. The compensation is declared by notification of the state, which in our case, that is Arunachal, was done in 2019 at the rate of 85% and 50%. I'll take you, Your Lordship, to these things. What happened in the present case? An arbitrary notification was made in 22, saying that people who have no rights will be given compensation at the rate of 50%. Now, Your Ladyship, the problem with that is multifarious. Number one, you are ignoring people who have rights under the 2006 Act. Number two, if you are giving money to people who have no rights, then central government, the Power Grid Corporation, has no authority to compensate you with that compensation, because they, as per Electricity Law 2003, Section 67(3), are empowered to compensate in full. Compensate is the word used, and it is the law for reassigning the
Is there any other counsel online also?
Pardon?
Is for this case only?
Yes, my lady, I am for respondent number 6. In both WBC item number 11 and 12, I am representing Power Grid Corporation of India Limited.
Oh, you're representing respondent number 6.
6. We are the executing agency, Power Grid. We have also filed our affidavit.
Well, I'll take your ladies. So they have filed, and I have filed a rejoinder to their application also. To their counter affidavit, I have filed a reply. And my submission, as far as they are concerned, is merely on the point that if compensation is to be given to someone who is not entitled to any compensation, they cannot refund that money to the state at all as per.
But what was the
Let me take you to page 32 of the two writ petitions are very similar, analogous. So I am using page the writ petition 32. Kindly come to page 29, Your Ladyship. I'll take you just to 3 pages for the purpose of the interim relief.
20?
Page 29.
Your petition.
Of my petition, writ petition 32. Now, Your Ladyship, if you see para 2A, right of way for 132 kV transmission line for the tribal population as identified in paragraph 3. I'll go to paragraph 3 later of this policy, and it is a direct contradiction of what para 3 says, who are not entitled for any benefits. Ladyship, you are not only ignoring people who have benefits, but giving benefits to non-existent people. Because by definition, resident tribals in villages have benefits under the 2006 Act. So that is being ignored. So it is blatantly wrong. The other problem with this approach, your ladyship, as I told you, was that now I take you to the Act, the Electricity Act. Your ladyship, you could have my copy if आप ये दे दीजिए. Electricity Act, if अगर है तो ठीक है, otherwise you can take my copy. (67)(3), your ladyship. I draw your attention to 67 clause 3, subsection 3. What it says very simply is, the licensee is responsible for providing full compensation for damages, detriment or inconvenience. I repeat, your ladyship, compensation for damages, detriment or inconveniences. This is referring to damages, inconvenience or detriment to property rights. Property rights or damages necessarily mean to someone. It cannot be somebody who has no, if someone is there who has no rights, then they cannot be having any right under this clause, and it is under this. So, your ladyship.
Where is the notification? You have an.
Yeah, look, I showed you the notification, your ladyship, page 29. Page 29, your ladyship. That's the notification.
Page 29.
Page 29 of 32. Your ladyship, I just read it. 31st August 23 date.
No, in item number 11, you're talking.
Ladyship, I'm talking of, there are two rates, 32 and 78. I'm talking of 32, which must be item number 12. It's item number 12. They are analogous, your ladyship. There are some 100+ persons in one rate, and these are the people whose lands are being affected. Page 29.
Now,
Lordship, may I read again? Para 2, your lady.
Mr. What to say? Now he is seeking most probably an interim relief, and that's why
My
he
lord,
is
let my friend argue, my lord. We'll clear the picture, my lord. Let him argue whatever he wants. We'll clear. There is nothing to for us to worry.
So, your ladyship, there is another for you. Let's say I have prepared a short note which covers the whole thing so that we don't have to go through each page. Wherever your ladyship wants, I'll take you to the relevant page. So this actually covers my case in brief for the purpose of interim relief. I am assuming we'll have time to argue the whole matter later when. Ladyship, like I just said, on page 29, para 2, Ladyship, the note I have given is also quotes out. So that will make it convenient for your ladyship. For the tribal population identified in para 3 of this policy who are not entitled for any benefits including compensation of specific nature, resettlement or rehabilitation benefit, an ex gratia relief package amounting equivalent to half the rates notified wide notice of 22nd September 2019. These are the rates actually as specified by the state. They have made it 50% ex gratia arbitrary to non-existent people. It contradicts directly para 3 in the same notification, which says, for identification of affected individuals where rows have been duly, where right of way, your lordship, ROW is right of way, have been duly granted by the competent authority in reserved forest area, a board of officers shall be constituted by the DC concerned at the district level akin to board constituted in matters related to land acquisition. So similar procedure is to be followed, is what the same notification. My lordship, they are automatically contradicting themselves. On one hand, they are saying you have to follow this procedure in reserved forest, and on the other hand, to identify the people, on the other hand, they are saying only for people who have no rights. Now, people who will be identified have rights under the 2006 Act. Then, Your Ladyship, I have given in my short note, Your Ladyship just sees my Your Ladyship, that will be much faster. Thus, impugn notification is bad in law on 3 counts at least. 1, it is assigning compensation of people without any rights to it. This violation of direct violation of Electricity Act, which specifies full compensation for detriment or damage, which means to person who has suffered the detriment or damage. This is in line with constitutional provision under 300A that a person's property rights cannot be taken away except by due process of law. As above amount is due to person with no rights, licensee, that is Power Grid Corporation, cannot possibly release budget for such ad hoc payment. That is 1. Second, law states the Electricity Act, which I just gave you, 67(3), very clearly says full compensation. You cannot have half compensation. So that is the second objection, Your Lordship. Clear violation of law by arbitrarily reducing it to half. Third point, Your Ladyship, is notification is self-contradictory. In last para 3, talks of identifying tribals as per provisions akin to land acquisition, where the property rights are protected under the 2006 Act. Now, Your Lordship, next page of the same, I'm just pointing out the laws relevant. The right to property, that is 300A. The Electricity Act, I have pointed out 67(3). Your Ladyship has the copy. Then, Your Ladyship, third and most important, the Nazir Ahmed principle. If something is specified by statute to be done in a particular, it has to be done in that way. Otherwise, as per the later ruling, Mackenzie, it is non-est ab initio. Your Lordship, in the third page, that is mentioned in the first para. Then, Your Lordship, the relief sought. Your Lordship, you may appreciate, even in the first hearing, my approach was not competitive. I was not asking for stay because this very court, in a similar matter, had given a stay, and later on, reconciliation was done by the DC concerned. A meeting was held, and a promise was made that proper compensation will be computed. And Lordship, that is the part I am asking for as relief. A walk may be organized, which is due procedure, and everybody's rights, as they claim, may be noted. They may be adjudicated upon later, but at least a noting should be made, Your Ladyship, because once things are destroyed, it will be very difficult to do it again. So balance of convenience lies in my favor. A walk may be organized. That's the minimum I am asking. In the next 2-3 weeks, Your Ladyship can very easily, Your Ladyship, we need not go into the strict adherence to the law, but mold the relief in such a way that the ends of justice are met and the work is also not disturbed. And arranging a walk is the easiest way, whereby all the people who have rights may come and submit the rights to the DC or the authority he assigns the task of the walk to. And after that, once this matter is adjudicated upon fully, the rights may be executed as per the orders of this honorable court. But interim, at least that much relief, which is minimal and non-invasive, non-disturbing, may be granted.
I'll take your Lordship to page 57.
Of item number?
Item 10. Item 12.
Item 12.
This is
57.
Yes, my lord. Since my learned friend has taken up item 12, my lord. Page 57. This is of 5th December 2023. it says, whereas the final joint verification and recommendation board was constituted for payment of diminution cost of land and properties of said so and so, so and so, so and so. Whereas the government of Arunachal Pradesh by notification dated July 18, 2020, published in the extraordinary and also published in the newspaper on 10th August 2023 for claims and objections of this 132 kV line in the affected villages. And whereas by so and so, dated so and so, has directed all concerned deputy commissioner to start all pending work of construction of double circuit transmission line under the project comprehensive scheme for strengthening of transmission and distribution system on Arunachal Pradesh in the state immediately for public interest. Therefore, the final recommendation board for disbursement of payment of the diminution and cost of land and properties to the genuine owners of this route, which comprises of the following listed members covering the affected villages under Pejilviam and Pasa Valley circles, Pakekesang district. This has been constituted, madam. Terms of reference to inquire the agency so and so, so and so. And then the board members shall carry out survey come identification of in page 58. Terms of reference item number 2. The board shall of officers members shall carry out survey come identification of genuine land owners with the help of concerned PRIs members and HGB, GB and GBs affected villages of the land falling within the proposed area for construction of so and so, so and so, so and so. Now, after this, madam, this was that. Again, their order at page 61, madam. Final joint verification was again done. Identified the genuine land owners have been identified, madam. Then at page 64.
By this order, genuine landowners have been identified?
Identified they are by all this. And at page 64, after the genuine landowners were identified, they were asked to submit at page 64. It is a circular, general circular. It is to for general inform to all affected genuine landowners for construction of 132 kV transmission line under Pasa Valley Circle, District, Pakekesang Lemni. They are hereby requested to fill in the final identification form at Office Circle Pasa and submit the following documents: Aadhaar card, voter card, bank detail, passbook, everything. Genuine identification. We are bringing it on record. Who are the all total 67 persons have been identified. Petitioners are not there. They don't have any claim. Thereafter, the compensation amount has also been paid to the genuine affected owners. In the month of March itself, we are bringing everything in on record. All genuine landowners have been identified. They have been also paid the compensation in the month of March itself. Now coming to the notification which is under challenge, my lord, of 31st August 2023, my lord, which
is under challenge.
Which the petitioner claims that this should not be implemented. We are bringing on records. We have not implemented that notification for disbursement to the genuine landowners, my lord.
Notification is that page?
At page 29, my lord.
Oh, yes, 29. Yes.
At page 29, my lord will kindly see. This is the notification under challenge, my lord. At serial number 2, right of way of for 132 kV transmission line. What it says, for the tribal population as identified in paragraph 3 of this policy who are not entitled to any benefits including compensation of specific nature, resettlement or rehabilitation benefits, and ex gratia amount equivalent to half of the rates notified in so and so, so and so, dated 2nd September 2019 would be payable. Here, the genuine owners have already been identified. The compensation as per 2nd September 2019, which is mentioned, full compensation has been paid.
It has already been paid.
Paid.
Your ladyship may be allowed to.
We are bringing all that on record, my lord, by way of an affidavit. And they are no way affected. This is what is called a reserve forest, my lord, what they are claiming is reserve forest. Now, reserve forest, whether they are entitled for any rights under a reserve forest, my lord, that is a matter to be adjudicated upon, my lord. But otherwise, the genuine landowners, because this land goes through an unclassified state forest, my lord, not the reserve forest, my lord. So their apprehension, their rights, first they will have to establish their right that they are entitled to compensation. But first they are required. Now, for that matter, therefore, there is no question of any interim order. Okay.
So now, okay then,
Your
the question
lordship.
is that,
May I, lordship?
you want to file your affidavit in opposition
Yes,
by
my lord.
bringing all this in the record.
Yes, everything. All the genuine landowners,
I'll
when
apply,
it was
lordship, I'll give a rejoinder to that. That's a thing. I'm talking of the interim right now. I accept 100% what he just said, except one point. That he is not giving the complete picture. I take your lordship to page 68. Page 68. Lordship, my entire case is not about just that impugned notification. All these things together are impugned because they are all linked. They are a chain. Page 68, your lordship. I read. May I read? Issue of notification of claim and objection for setting up transmission line. Now they are referring to para. Reference is invited to the subject item, reference cited. Para 2. This is regarding issue of notification inviting claims and objection in terms of section 67, 68 and 164 under Electricity Act 2003, Railway Telegraph Act 1885. This as per law gives the procedure for alienating rights. 3. Now this is where the devil lies in the detail, your lordship. The matter has been examined in consultation with Department of Environment and Forest and Department of Law and Justice. They sit inside a room and examine. And this document, which gives rights to people in reserved forests, all kinds of forests, is just thrown out of the window, sitting in a room. Para 4. Look at the sweeping statement that is being made, your lordship, and they are relying on this. There is no requirement of issue notification inviting claims and objections for setting up the transmission lines in reserved forest areas, notified forest area, protected forest area under Electricity Act. Electricity Act does not talk about this. Electricity Act merely says full compensation has to be paid to whoever is affected. The Right to Fair Compensation and Transparency and Land Acquisition Rehabilitation Resettlement Act 2013 talks about this. This is selective amnesia, your ladyship. Now what they have done, the lands for which we are settlers or we are having rights are in reserved or notified forest areas. We came to know when people came to put concrete pile foundations on the chest of our land and destroy our crops. That is how I came to know how this is happening. And your ladyship, we are not against it. But to say that we don't exist, what this notification or this letter and notification together are saying, that in these areas, people like me, and there are more than 100 in front of you right now, your ladyship, just don't exist. We are non-existent. And they claim they have given money to everybody. I'm sorry, your ladyship. And they say we have given to everybody and in full. I'm sorry, your ladyship. The money they have given To those they have given only half the money. The full money was arbitrarily reduced to half. That is a point I will argue when we are arguing the matter. But at the time, my existence as a human being in the forest must be recognized. Your Ladyship, I want to take you to a small para from the judgment of the copies that I have just given to you. Yeah. Ladyship, there is a judgment of 2000 here. If you can go to page 23 of the writ petition, this is from the judgment of final judgment and order of 2009 in writ petition 20 of 2009. It's a very pertinent para 23 on page.
Can I have the citation number?
Yes, citation number is, I don't know the citation number, but it must be here. I'll just tell you when I don't remember it. But I have, it's in, it's annexed. The whole thing is annexed. If I can just take you to page
No,
120.
I'm sorry to interrupt. I'm sorry, my lord, but if a judgment is being referred, if we can have the citation number.
I'll try and give it to you. Can I just go through my submission? Then I'll try and give it to you. Okay. It is petition mein annexed. If you look at the petition, it's annexed, and I'm talking of page number in the petition. Okay.
Page number?
Page number
It starts from
120.
122.
120 on my this thing. Page 120, para 23. Last portion. Page 120, Your Ladyship. Internal page 23.
Yes.
Yes, Your Ladyship, I'll read the last para, last portion, 23, para 23, last portion. The state must provide protection to these people. They are talking of residents in reserved forests. Under the provisions of 2006 Act, which has recognized the rights of the forest-dwelling scheduled tribes and other traditional forest dwellers, who has come into force with the publication of the same in the Official Gazette of Government of India on 2nd January 2007. The government is bound to consider the applications, if so submitted by the petitioners, for protecting their rights and privileges under the Act. It is the duty of the government to inform and educate the indigenous tribal people dwelling in the forest about their rights granted under the said Act, and to take necessary actions so as to enable them to enjoy the said Act. Our Ladyship, the point I am making is, there is a duty cast on the government because of the underprivileged position of these tribals to even educate them about their rights. At the moment, several LPCs are pending, arbitrarily cancelled or not considered. The people went to get their LPC registered, they were refused. So all that has been raised in the main petition. But for the time being, at least a walk can be arranged and rights of the people, as they are claiming, may be noted somewhere for future reference so that they can, once adjudicated upon, be compensated adequately. I am not asking for immediate compensation. I am not asking for stay. Nothing could be more reasonable in terms of a demand of a people whose existence has been denied. As per this set of orders, I don't exist in this state. That humbly is my submission. Interim order just allowing a walk to identify the right holders. And their rights also may be adjudicated upon later.
Obviously, but as per their submission, the government side, most probably those the peoples are already been identified.
No, Your Ladyship, this is what I just pointed out from it. In reserved forest, they issued a letter saying that need not be done. So the entire procedure, my learned friend pointed out, has not been executed in our area under this letter.
2006.
So everything has been done, everybody has been paid except those in this area.
No.
Nothing, no step has been taken. And I say that with tremendous responsibility.
The matter may be heard finally.
No,
The order.
Ladyship, all you need to do is in that area.
How can we direct them?
Your Ladyship, this bench gave a stay order in a similar case, which I have attached to, but I am not going to that because I am not asking for a stay. I am asking for minimal intervention that at least record the rights of the people as claimed rights, not even as substantiated
Obviously,
crystallized
okay,
rights.
then now question is that as an interim, we cannot direct them.
Your
to
ladyship,
rectify.
actually, as per law, they cannot start the construction without giving compensation.
My
That's the
lord,
law.
my lord, I may also be given an opportunity to address the court. So we
Yes,
arrive
yes,
at a
yes,
better stage of adjudication. If my learned senior here is content with the submissions, I may. Now,
Yes, yes, you
what the problem here is that, my lord, the petitioners here, they are confused, and the law they are trying to present and the notifications, they are only picking up bits and pieces out of it. Now, first and foremost, my lord, the work which is being executed, we have been empowered to execute this work by exercising the powers as are enshrined under the Telegraph Act and enjoyed by a telegraph authority. Now, Section 164 of the Indian Electricity Act, if I can,
Yes, yes.
my lady can go to
Yes,
Section
yes.
164 of the Indian Electricity Act.
Hmm.
And simultaneously page 26 of my counter affidavit in WPC 78, that would be item 11.
Your page number affidavit in?
Page 28 of my counter affidavit.
Hmm. Yes.
Page 26, page 26. It's a Gazette notification dated 24th of December 2003.
Hmm.
If I may,
Yes.
para 2 onwards, it says, and whereas Power Grid is required to establish transmission system and to undertake transmission of electricity through the interstate transmission system, and whereas for placing and maintaining of electric lines or electric plant under, over, along or across, post, in or upon any immovable property for the transmission of electricity or for the purpose of telephonic or telegraphic communications necessary for proper coordination of work, and vesting and exercising of the powers of the Telegraph Authority under Part 3 of the Indian Telegraph Act 1885 with respect to the placing of the telegraph lines and posts established or maintained or to be so established or maintained are required to be conferred on the Power Grid. Now, therefore, in exercise of the powers conferred under Section 164 of the Electricity Act 2003, the Power Grid is hereby authorized to exercise all the powers vested in the Telegraph Authority under Part 3 of the Indian Telegraph Act 1885 in respect of electricity lines. Now, in exercise of these powers, my lord, we may go and visit the Indian Telegraph Act. Section 10 very clearly says we do not acquire any other right other than the right of a user.
Hmm.
And under
Yes, you go. Carry on.
Section 10 clearly defines and says that Power Grid will only acquire the right that of a user and no other right. Now this, why? Because they have used the word acquisition over here to suit their convenience whenever they want in their submissions. I'll satisfy the court and Lordship may decide upon the same. Now, Lordship, under Section 10, specifically 10D, we are dealing with Part 3. 10D, in exercise of the powers conferred by this section, the Telegraph Authority shall do as little damage as possible, and when it has exercised those powers in respect of any property other than those referred in clause C, shall pay full compensation for the damage sustained. The catchword here is, Lordship, damage sustained. Now, what does 10B say? 10B says the central government, that is us, the authority, Lordship, shall not acquire any right other than those of user only in the property. 10B. As per 10B, I am a user. I have not acquired any other right. And as per 10D, I will pay only that much of compensation which has been sustained over the land for any of the damages. Now, Lordship, a landmark judgment to this effect was given in SCC 2017-5 SCC 143, Power Grid Corporation of India Limited versus Century Textile. 2017-5 SCC 143. They have very categorically decided, Lordship, as to from para number in that judgment, from para 22 onwards, para 22, 23, 24, 25, 26, 27, 28, 29, and 30, as to what is Power Grid, what are the powers that it enjoys, and what are the powers that are enshrined upon it, and the compensatory payment mode. Now, Lordship, after this, what happened? In the year 2015, the central government, they came up, in a conference which was held, they came up with certain guidelines saying that in addition to the compensation that is paid for the damage sustained, the exact correct word and proposition would be, Lordship, for surface damage and or tree crop compensation, which the land might have suffered while planting of towers. Now in 2015, the central government stated that it was a guideline of suggestions. The guideline was not imposed in 2015. The central government stated that for the purpose of additional compensation, apart from this surface damage tree crop, an additional compensation in the value of diminishing land value, that would be 85% of the tower base area, that is the area between the four legs of a tower, and 15% between the right of way. Now, Lordship, right of way would mean the stringing of the transmission line between two towers. The lines which are pulled, this is what we call as right of way. Now, that notification also stated, the 2015 notification, that these guidelines will only be applicable when they have been adopted by the state government. So, Lordship, their writ petition itself, page 30, WPC 32, page 30. Can we have it in WPC 78? Lordship, page annexure 18, page 38. Now, if I may, Lordship, this is essential to the matter at hand. Now, what does this say? This says the governor of Arunachal Pradesh is page 38, Lordship, it's the type annexure 18.
38.
3030A alpha.
Okay.
WPC 32.
Yes.
May I, Lordship? It says the governor of Arunachal Pradesh is pleased to adopt and notify the following rates of payment of compensation towards damages in regards to right of way for the transmission lines in accordance with the guidelines of the Ministry of Power, Government of India, wide reference number 37/2015, transmission dated 15/10/2015. This is the guideline which I spoke about, Lordship. Now the state here is adopting it for maintaining uniformity in compensation payment to the affected landowners. Now, Lordship, may please see the word here in this notification, to the affected landowners.
Yes.
During construction of transmission lines, it has been decided that a similar payment methodology towards compensation shall be adopted in the state of Arunachal Pradesh. These guidelines of payment methodology for compensation towards damages as stipulated in section 67 and 68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885, shall be in addition to the compensation towards normal crop and tree damages. I hope I'm being able to make my point here, Lordship. Originally, perennially, the compensation was only paid for the damages to the crop, tree, and if any damages happened on the land when we were installing either the tower or stringing the transmission lines between two towers. 2015 central government stated, let us have something in addition to these also. However, they will only be applicable once the state government has adopted them. On 29th of August 2019, the state government of Arunachal Pradesh adopted these guidelines and say that these are in addition to the perennial compensation that is under Section 10 of the Telegraph Act. Now, they say that these are only for the affected landowners, not land occupants, not settlers. Then what happens? Gotcha. Now we come to the notification for which they have come to the court, that is at page 29, annexure 1. Page 29, annexure 1. Now what happens, Lordship? In 2023, rather to be specific, on 31st of August 2023, the state government of Arunachal Pradesh, they issue a notification wherein they say that there is another category of people who are forest dwellers. They are not the landowners. It is forest land, Lordship. We have paid compensation. We have taken permission from the government agencies when we were doing this construction work from Ministry of Environment and Forest. I'll come to that at an appropriate stage in my arguments today itself. Now, the government of Arunachal Pradesh say that let us identify another category of people. They are not the landowners. They are forest dwellers. They say, since these people, they inhabit in the forest, they have a livelihood coming out of the forest.
Yes.
So let us give them some form of compensation. Then so how do they give them? At para 2, specifically at 2A, Lordship, if I may read it, it says, for the tribal population as identified in para 3. Now, we will go to para 3 subsequently to understand who are these people of this policy who are not entitled to any benefits, including compensation of specific nature, resettlement or rehabilitation benefits, and ex gratia relief package. Amount equivalent to half of the rates notified via notification number PWRSE 24 this so-and-so 2nd September 2019. The notification we have just gone through, Lordship, at page 30A, where they adopted in addition that 85% and 15%. It says payment will be computed at 42.5%, that is 50% of the 85% for the tower base area, and 7.5% for the stringing, that is the right of way. Now at para 3 of this notification, they say for identification of the affected individuals where ROW have been duly granted by the competent authority in reserve forest area, a board of officers shall be constituted by the deputy commissioner concerned at the district level akin to the board constituted in the matters related to the land acquisition. The representative of the forest department shall be necessarily included in the such board for identification of persons. There is no land acquisition happening, Lordship. Why it is not happening also, I will come to it. So what the government did is, government came with a policy decision saying and stating that people who are not entitled to any benefit, but because they are living in the forest, they are forest dwellers, let us give them something out of their own accord. These transmission systems have not come yesterday and today, Lordship. They are here for decades. But for the first time, as a welfare measure, government comes and says, now they are trying to come and stab us. Next, the land acquisition, Lordship. If we can, Lordship, Land Acquisition Fair Compensation and Land Acquisition Act 2013, if I can...
Land Acquisition Act 2013.
And Lordship, I am sharing the judgment in Century Textile over this online screen itself. I'll share it and Lordship can peruse it for final adjudication. Now, Lordship,
No,
in the
it's
land.
okay. Final argument stage, we'll hear all these things.
Okay,
Now,
now-
in 2013 Act, what do you want to say?
Lordship,
Land acquisition?
section 105.
No. 31, 32.
2013 Act, because that is the act which they have stated in their petition is applicable according to them. It's in their prayer. They may say yes, no, it is in their prayer. They, like I said, they are confused, Lordship. What do they exactly actually want also? All I am doing is presenting the proper proposition of law. Section.
So maybe allowed to clarify 2-3 points. I'll just clarify
No,
2-3
it's okay. I'll pass the order.
Let me.
Lordship, I just clarify 2-3 points. One is the
Lordship,
the
let me
phrase
complete.
land acquisition has not come from us directly. It is rooted in the notification of 31st
Lordship.
August, where the last para says akin to land acquisition, which
Yes,
is why we
Lordship.
have used. And we are not talking of Land Acquisition Act. We are talking of the tribals, the Forest Dwellers Act.
Lordship, I may be
under
allowed
which
to come. I may be allowed to
LPCs have
complete.
been issued in our state, which are akin to land holdings, which are property titles.
Lordship,
And
am I audible?
all of us are having that kind of status.
Am I audible, Lordship?
Yes, you are.
Let me complete. I will respect. I mean, I will not be interjected in it. Let me complete, Lordship. If we can have the Right to Fair Compensation Act.
2013 কোন প্ল্যান আইনি কেন কেন আসবে কোনো থাকি বলে
मेरा ले लीजिए. I'm not referring to this.
Yes.
Lordship, section 105.
Yes. Yes, section 105, provision.
Provision. It says, provision of this act not to apply in certain cases or to apply with certain modifications. Subject to subsection 3, the provisions of this act shall not apply to the enactments relating to land acquisition specified in Schedule 4. Now, Lordship, Schedule 4 to this Land Acquisition Act, it would be, I believe, the second last page of this enactment, Schedule 4.
Yes.
Entry 12, entry number 12. The Electricity Act has been exempted. Now, the notification which they are saying, Lordship, the notification does not say that it will be like land acquisition. It is saying the board which will be constituted will be a board.
Exactly.
Sir, can I complete with all humbleness?
I'm sorry. I'm just talking to myself.
Sir, thank you. So, Lordship, there is no question of land acquisition anywhere. The Supreme Court has come down very clearly. Now, Lordship, where will we revert back? We will revert back to the Telegraph Act. And I will be culminating my submissions with it, Lordship. Section 16 of the Telegraph Act under Part 3. If I may. Section 16, Lordship.
Okay.
Specifically, section 16.3 and 16.5. 16.3, 4, and 5. May I, Lordship?
Yes.
If any dispute arises concerning the sufficiency of the compensation to be paid under section 10 clause D, it shall on application for that purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated be determined by him. 16.4. If any dispute arises as to the persons entitled to receive compensation or as to the propositions in which the persons interested are entitled to share in it, the telegraph authority may pay into the court of the district judge such amount as he deems sufficient, or where all the disputing parties have in written admitted the amount tendered to be sufficient, or the amount has been determined under subsection 3, that amount, and the district judge, after giving notice to the parties and hearing such of them as desired to be heard, shall determine the persons entitled to receive the compensation, or as the case may be, the proportions in which the persons interested are entitled to share in it. 16.5. Every determination of a dispute by the district judge under subsection 3 or subsection 4 shall be final. Lordship, when the act in itself gives them an alternate remedy, the law is settled, they cannot come to an equity court and get the writ jurisdiction exercised, Lordship. There are matters of dispute over here. The matters of fact needs to be adjudicated. They are, because they have to clarify their stand. What is the issue? Are they challenging the policy decision, or are they upset with the quantum of compensation given to them? Because if they are challenging the policy decision, the state has to file an affidavit to be heard. And if they are challenging the quantum of compensation, Lordship, they will have to go to the district judge under section 16, because law has identified that particular institution as being the final authority. As on date, they were somebody who were not entitled to get a single penny. That notification gives them something. Now they are saying interimly suspend the notification. Whether that notification continues or it gets suspended, nobody will reap any benefit. The state, it's a policy decision of a state. The state government has to file an affidavit and bring out their stand, Lordship. Because I am not, Lordship. But if they say today, if they say that they are not satisfied with the quantum of compensation, this writ petition should be dismissed forthwith, giving them the liberty to go and approach the district judge under section 16.3. For sufficiency of compensation, they cannot get this court to exercise a writ jurisdiction where court will say, no, you give them compensation at X amount or X percentage, Lordship.
Okay.
That is a decision which will not be tenable. So, Lordship, and right now, there is no question of any interim or suspending any notification. A, and they should be asked to make their stand clear today. If it is about the quantum of compensation, or they are trying to come here as a public interest litigant. But either way, today no interim relief can be given to them, and no interference with the policy decision be done, Lordship, because it is being done for the greater welfare of people who are forest dwellers. Most obliged, Lordship.
I have already heard you.
Yeah, Ladyship, very briefly, because he made some relevant points. Again, like my learned friend here, 98% I totally agree with him. I just want to mention 2 points to him. One, he said, we are people who are not having any rights and we have been given something. And what is it that we want? Your Ladyship, what we want is very simple. We want to be identified as people who have some rights and are in those forests. At the moment, we have neither been given anything, and we have been completely left out by the set of documents which says, one, that the reserved forest, there is no need to do identification. The purpose of using the term of land acquisition comes from their own notification, which says that the process and that is all what we are also talking about. We are in agreement with what he is saying, except that he is not appreciating 2 things. One is that our identity has been completely denied under the present position. Second thing is that the entire amount is arbitrary, not for us, but by notification itself. It's not in line with what he himself has said, which I read to you. So all that I am asking your Lordship by way of interim relief is identification. And that can be affected by a simple walk in the relevant area. We have just been denied our existence. Much obliged.
They don't have a prayer to that effect in their petition. I'm sorry to say this, we are also confused. What have they filed? What do they want? And
We
what
are
they doing?
challenging the notification, and as well as in the interim, they are asking for something which is in that notification, which they are challenging.
Ladyship, what they are not appreciating, my learned friends, is that under the Forest Dwellers Act, we are having rights akin to land rights, the LPCs which are issued. And many of us have LPCs, and some LPCs were cancelled, some are pending. So this is an important point.
Okay, I'm
In a parting humor, I think they should withdraw it and file it with regards to what they actually want.
I think the problem is of understanding, not our desire or explanation.
Much obliged, Lordship. Lordship, next date, if could be given, Sir and me, we both are outstation counsel. So, and I think state
So
will have.
yes, Mr. Ratun, what do you want to? I'll pass the order on interim only today.
Yes, madam.
Yeah.
And you want to file the affidavit,
Let it
right?
be after 2 weeks, madam.
After 2 weeks will be convenient for you, after 2 weeks, or want any fixed date?
Lordship, fixed date would be convenient. I'll
Fixed date
personally
would be convenient.
come.
Okay, fixed date.
As per sir is coming from Delhi.
Otherwise, we are going
Huh?
to fix it on 19/6. 19/6.
19
19 will do.
after 2
Mr.
weeks.
After 2 weeks, 19 will do.
Lordship, if we can come up on the
27th.
27th.
27th, I am in a different matter in
You're saying
Guwahati,
24th?
Guwahati High Court.
24th.
24th can be?
Yeah, that's-
Okay, then 24th.
24th.
Okay.
Lordship,
24th is
Lordship, my work may not be affected with regards to this policy decision because it's a national project.
Let us see
Actually,
what the
I'm not
interim
even
order-
asking for, I am asking for no relief which will affect his work. I don't know what his anxiety.
Obliged, Lordship.
Okay. Item number 17. ये सब किताब से आपको डाल के वहाँ पे दे देना। सील भी कर दी है, चमड़ में दे देना। नाम लिख देना। वो अभी
May it be Lordship, my lord, this matter pertains to my lord land combination regarding solicitum and the interest 12%.
We are on
My lord,
item
this
number
has been,
17.
yes, this has been stated by the Honorable Apex Court. So I think this has been wrongly came up today.
Wrongly.
Yes,
Why it was listed for?
because stay order has been granted by the Honorable Apex Court.
There's similar matter in the
The
apex
similar
court.
matters are
By the apex
pending
court,
by
yes.
you.
Stay was
Still
there.
pending, yes, madam.
So this may be fixed after the Honorable Apex Court provides
Just
certain
give it.
reliefs.
I don't know. Yes. This is the case. Is there any observation in the earlier order? Oh, it says similar matter will be same issues pending before it run. Then why it has been fixed today?
That's why. That's right.
Or Mr. Isom. Also for the petition, I also heard MS so and so. You are DSP,
T1, yes, ma'am. No, madam, for state government,
state government advocate
Yes,
or
government advocate.
government advocate? It is submitted by Learned Counsel for both sides that the matter is wrongly listed today as by the order dated 24/4/2024. And the matter was ought to have been listed after the outcome of outcome of the matter which is pending before the apex court. List accordingly soon after the outcome of the matter in which is similar matter which is pending before the apex court. List accordingly. Okay. To the list.
Well, this matter is pending for since 2023, October. So no any response has been filed by the opposite part respondent.
No any?
No any response.
Lordship, no extra copies has been served to us till now.
You have not served the copy.
Extra copy already served. Regarding pay fixation one, enhancement of pay.
No, yeah, you have to submit the affidavit in opposition.
Yes, Your Lordship.
You are appearing for respondent number 1,
1, 2, 3, 4, 6, and 7.
1, 2, 3, 4, 6, and 7.
Yes.
I am appearing on behalf of T. Tagun, Standing Council for Health.
Head. For respondent.
5, 9.
No, you are for 1, 2, 3, and 4.
1, 2, 3, 4,
And 7.
6, and 7.
6 and 7. And you are for 5.
5, 9, 10.
5, 9, 10. For the health, na?
Health.
Health department. 5, 9, 10, huh? So extra copy, have you received the extra copy? Now she is saying that she does not.
I have not received it.
Not received.
I'll furnish the copy today.
Already furnished.
Today. I'll furnish.
By today.
Yeah.
So how many weeks you need for?
4 weeks,
affidavit
Your
in
Lordship.
opposition? Huh?
4 weeks.
Yeah, your affidavit of opposition you have already filed or not yet?
No.
Not. Mr. Kishon, you done it also for the petition and also. Ms. So you done it. Permit advocate appearing on behalf of respondent number 1, 2, 3, 4, and 6. Yes. 4, 6, and 7. And also heard Mr. T. Tagun.
I am appearing on behalf of T. Tagun and
Okay.
Arco Unity.
Standing council.
So and so appearing on behalf of Mr. T. Tagun, the Standing Council of Health Department, representing the respondent number 6, 9, and 10. And it is submitted by MS so and so, the government advocate, that she has not been she has not provided with the extra copy of the petition. And so that the affidavit in opposition can be prepared. Mr. Som, they accordingly furnished the copy of the extra copy of the petition today itself in the court. Let the matter be listed accordingly after 4 weeks, enabling the respondent side to file their affidavit in opposition. After 4 weeks, you file your affidavit in opposition.
After 4 weeks means after vacation. Or summer vacation.
After summer vacation?
4 weeks.
After summer vacation. Okay, it will be
Or
listed
like
after summer vacation. Item number 19. Yes.
All right, this is a review petition by the statement.
By the state.
That certain basic facts which form part of the records were not brought to your lordship's notice. Perhaps that is why this error has crept in. And may I place the facts quickly, madam? But the opposite party here, the writ petitioner, has preferred this writ petition in his individual capacity. But what he says is, if your lordship will, we have annexed the writ petition. These are the, if your lordship will straight away first come to the writ petition, which we have annexed as Annexure Q at page 96. And if your lordship will
96.
page 96.
No, 96 is not the 96 decided. You were on page 96.
96.
96 is. Acha, okay. Acha, the repetition. Yes.
This was the writ petition on which the order was passed. If your lordship will kindly turn to the body of the writ petition at page 107. that reflects the petitioner. Who was the petitioner?
Hmm.
Petitioner is one Mr. Sri Likha Maj. And now if your lordship will kindly turn to para 3 of the writ petition.
Yes.
That the humble petitioner herein is the proprietor of Sahil Enterprise, Mia Tom Enterprise, Sahil Transport Corporation, and power of attorney holder of Sela Transport and Rinchin Kharu. So none of these entities come. He comes in his personal capacity, prefers this writ petition, and the claim is based on there were separate agreements. Page 152. This is again part of the writ petition. There are 5 different agreements. This is a carriage transport contract. Page 152 is one of the agreements. Your lordship will find there were 5 separate agreements. Page 52 is 152 is one of the agreements. Then thereafter, this is the type copy. We have annexed the original at page 158 onwards. So your lordship may just make a note, madam. These separate agreements are annexed from page 152 to page 200 of the review petition. And what is, besides the fact that these were all separate agreements made with these separate 5 entities, your lordship will find another interesting thing, that in these agreements there is no provision for any interest. Now, apparently, separate bills were submitted, which added up to a total of 44 crores. And on these, when these bills were apparently not clear, he preferred a writ petition earlier. And that your lordship will find at page 38 of the review petition. This was the earlier writ petition that was filed. And if your lordship will kindly turn to page 45, your lordship will find the prayer. In the premises aforesaid, it is prayed that your lordships may be pleased to admit this petition, call for the records, and issue a rule calling upon the respondents to show cause as to why a writ in the nature of mandamus shall not be issued, directing the respondents to forthwith release the outstanding bills of the petitioner amounting to 44 crores, and on cause or causes shown, etc. etc. What I wanted to point out from this is, in the earlier writ petition that was filed, there was no claim for any interest. So, and this aspect of the matter was never brought to your lordship's notice. On this, an order was passed, which your lordship will find at page 47. This is an order passed in this writ petition, WPC number 170 AP of 2018. And it was dealt with. Your lordship will find the operative part of the order at page 48. In the considered view of this court, on perusal of the entire facts of the case, and after hearing the learned counsel for both sides, this court is of the view that the instant petition is covered by the decision rendered in the aforesaid writ petitions. Therefore, the respondent authorities are directed to make payment of the bills of the petitioner amounting to rupees 44 crores, etc. within 4 months from the date of receipt of a certified copy of this order. Against this, the state filed a writ appeal. While the writ appeal was pending, this amount got sanctioned. And that your lordship will find at page 64. And this order, sanction order has a great significance. I'll come to that. Page 64.
Yes.
Your Lordship will first make a note of the date at the top right-hand corner, 26th of August 2021. And the order number is also reflected on the left side. Now, out of this 44 crores, an amount of the governor of Arunachal Pradesh is pleased to accord an expenditure sanction not exceeding 6 crores 72 lakhs 30,000 only, being the part payment out of the total admitted claim of 44 crores 82 lakhs. This is the amount ordered to be paid by this honorable court, by the honorable single judge. Out of this, 6 crores, etc., was sanctioned. Thereafter, my lord, when the writ appeal came up, if your lordship kindly turns to page 66, this is the order passed. Towards the page 68, para 5. As the applicant number 1 has admitted the claim of the petitioner to the extent of 44 crores 82 lakhs, etc., the exact amount which is ordered to be paid by impugned judgment and order dated so and so in WPC number 170, etc. In the considered opinion of the court, in light of such admission, the instant appeal itself has been rendered infructuous. In view of the discussion made above, the cause of action of the present appeal does not survive, and accordingly, this writ appeal stands dismissed on admission of the claim of the respondent and the judgment and order dated so and so passed by the learned single judge. However, the court is inclined to take note of a part payment of 6 crores 72 lakhs so and so, as indicated in order dated 26/8/2021. At this stage, the learned senior government advocate makes a prayer that at least 3 months' time be allowed to the state to make payment, etc., etc. And accordingly, this was granted. Now, my lord, first, thereafter, page 70, your lordship will find the balance amount that remained out of that 44 crores, out of which 6 crores, etc., was sanctioned earlier. Now, the balance amount is also sanctioned, and the payment is in entirety is made. Now, once this payment was cleared, he started submitting representations that there has been a delay, now give me interest. And what he does is interesting. He files a writ petition, which was numbered as 257, which your lordship will find at page 77. WPC number 257 of 2022. 23, it should be 23. Now, if your lordship will kindly come to page 93. This is not very legible. A copy of this is also page 93. It is also annexed at page 73, my lord. Your lordship will kindly have page 93 with page 73.
70?
73. This page 93 is what was annexed to the writ petition earlier, 257. Page 73. And your lordship will simultaneously also have page 64. Your lordship will find it is the exact same order at page 64, which was annexed to the writ petition. There is one glaring difference. In the third line, your lordship will find the original order says that 6 crore 72 lakhs, etc. is sanctioned, only being the part payment out of total admitted amount of 44 crores. If your lordship takes off page 73, your lordship will find that this 44 crores, it is the same order. It was how it became 141 crores. God only knows. I am not imputing anything further at this stage. If necessary, we will take appropriate measures if it comes to that. Now, the writ petition got filed like this. Perhaps it was realized and this writ petition was withdrawn, which your lordship will find at page 75. That is why, my lord, I have nowadays started believing that even when your lordships we come and make submissions that we may be allowed to withdraw the writ petition. Nowadays, perhaps a time has come where lordship will have to be careful. Why it was withdrawn? A simple prayer is made. Page 76 is the order. And when such an innocuous prayer is made, obviously no one will doubt anything. Simple prayer. On the prayer made by Mr. So-and-so for the petitioner, the writ petition stands dismissed on withdrawal with a liberty granted to the petitioner to file afresh, if so advised. Now, again, the writ petition, since liberty was taken, this time another writ petition is filed. This time the correct order is annexed. And a prayer is made for payment of interest. This time, this writ petition, your lordship will, as I was pointing out, is at page 96. And your lordship, if your lordship kindly comes to page 133, where is the prayer made in the writ petition.
Yes.
First prayer is a specific prayer release. A writ in the nature of mandamus should not be issued to direct the respondent number 1 and 2 to release the outstanding admitted payable amount of rupees 96 crores 77 lakhs to the firms, etc., etc. Then prayer B, he asks for interest of 20%. And this 96 crores is apparently based on some certificates or some documents prepared by some officers. And in this writ petition, the state had filed an affidavit saying that these officers were not even authorized. I'll place all of that. That these officers were not even authorized to make. And these calculations, this 96 crores, which was shown from some calculations done, these were mere internal calculations. And these authorized were not, these officers were never authorized to issue any such document. I will place that specific stand of the state from the affidavit. Now, based on this, your lordships, your lordship passed the order, impugned order, which your lordship will find at page 139. Oh, I'm sorry, but it should be 379. since very innocuously a prayer was made, prayer A, as I pointed out, that released 96 crores. Therefore, based on that, your lordships, while recording the facts at paragraph 2, page 380, naturally based on the prayer, your lordship went by the prayer made. The writ petition has been filed praying for release of petitioner's outstanding bills amounting to 96 crores. It is not outstanding bill. It is a claim for interest. So therefore, the very foundation as it has been recorded in the writ petition because of the prayer made is incorrect. This was never a writ petition for any outstanding bill. This was a claim for interest on that 44 crores. So therefore, on account of all these things and the fact that the earlier writ petition where a specific prayer was made for releasing the 44 crores was not even pointed out to your lordship. Had it been pointed out, the first thing your lordship would have said is, this is clearly barred by constructive res judicata. Since that writ petition was not even pointed out to your lordship, otherwise your lordship would not have proceeded any further. Now, based on this, now one thing that had happened was in the affidavit file, for whatever reason, my lord, I am not trying to attribute anything. If your lordship will kindly come to the very foundation of the order is paragraph 2. Thereafter, paragraphs 7 and 9. Your lordship will find paragraph 7 at page 384. 384.
Yes.
Mr. So-and-so, learned senior government advocate, submitted in this regard that the government has already admitted the outstanding bill amount of so-and-so only, and on instruction received, the claim of the petitioner is not opposed. But it is submitted that due to lack of funds, etc., could not be released on time to the petitioner, and the respondent authority is ready to pay the outstanding dues to the petitioner in installment basis, etc. And based on this, your lordship recorded at para 9. Next para. However, considering the submissions made by the learned senior government advocate, so-and-so, I find it justified to direct the authorities to clear the outstanding dues in the installment base. This, in my respectful submission, there is no admission in the affidavit, or there was no admission in writing. Never. We never admitted in the affidavit. So the first submission, my lord, on this issue is this. On this issue, my lord, the law has been very clearly laid down very long back, way back in 1991. If your lordship will have this judgment.
The calculation which have been made.
This
96 crores.
I will come to that on my next submission. This calculation, whoever made that calculation, the stand in the affidavit filed in the writ petition was that these officers were not even authorized. I'll place that. Next, immediately I am coming to that. In fact, my lord, if your lordship so desires, your lordship will straight away come to that. The affidavit in opposition filed by the authorities is at page 297. And your lordship will kindly come to paragraph 8 at page 301. This position was never brought to your lordship's notice. That in regards to the averment made in paragraphs 9 and 10 of the writ petition, humble deponent states that the certificates are born out of records But the then Secretary and Director Foods and Civil Supplies are not competent to calculate interest amount and issue the certificates. And the reason also I'll point out to you, Lordship. This calculation was on the basis of a 13% interest. What is the basis for the 13% interest? Why not 12%? Why not 14%? There has to be some decision as a matter of policy. Why 13? Why not 18 or 20? Because the claim made in the writ petition is 20. It could have been 20 also. So these were internal documents which were taken out from the records, maybe by filing RTAs and annexed to the writ petition. But the stand of the government, as reflected in paragraph 8, was not brought to your Lordship's notice, which led to this error. Now, my Lord, if your Lordship will kindly have this judgment, I can very well understand once this kind of a submission comes, it becomes your Lordships take us on face value. But the law in this regard is very well settled by judgment of the Supreme Court. This is 1991, Volume 4, SCC 195. The relevant paragraph is paragraph 19. It's a very, very long paragraph, so I won't trouble your Lordship with the whole paragraph. I will just point out the relevant portion. Paragraph 19 starts at page 207.
Yes.
What is relevant is at page 209. If your Lordship will have page 209,
Yes.
the fourth line from the top, your Lordship will find a sentence starting any concession. Any concession made by the government pleader in the trial court cannot bind the government, as it is obviously always unsafe to rely on the wrong or erroneous or wanton concession made by the counsel appearing for the state, unless it is in writing or instructions from the responsible officer. Otherwise, it would place undue and needless heavy burden on the public exchequer. But the same yardstick cannot be applied when the Advocate General has made a statement across the bar, since the Advocate General makes the statement with all responsibility, and so on and so forth. So therefore, if your Lordships, your Lordships normally do, whenever a government counsel makes a submission, your Lordships take the instructions and make it part of the record, so that it is in compliance of this judgment. Now, my Lord, coming to the next issue, which I have already pointed out to your Lordship, had the earlier prayer made in the earlier writ petition been placed before your Lordship, which again, quickly to point out, this WBC 178 of 2018 was filed earlier, claiming the 44 crores. There, I had already pointed out the prayer. If your Lordship will kindly have it once again. That writ petition starts at page 38, and the prayer is at page 45. There, he ought to have made a prayer for interest, but he did not. If that is so, this subsequent writ petition is clearly barred by constructive res judicata. Had this writ petition with this prayer been pointed out to your Lordship would not even have entertained it. Your Lordship would have dismissed this writ petition as not being maintained. Or at least your Lordship would have discussed the issue. Even to reject, your Lordship would have considered the issue. But this was never brought to your Lordship's notice. And on constructive res judicata, there is a judgment I would like to place. 1986, Volume 1, SCC, page 100. 1986, 1 SCC, page 100. And the relevant paragraph is para 20.
Yes.
So far as the first reason is concerned, the High Court, in our opinion, was not right in holding that the earlier judgment would not operate as res judicata, as one of the grounds taken in the present petition was conspicuous by its absence in the earlier petition. Explanation 4 to section 11 CPC provides that any matter which might and ought to have been made ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. And adjudication is conclusive and final not only as to the actual matter determined, but as to every other matter which the parties might and ought to have litigated and have had it decided as incidental or essentially connected with the subject matter of the litigation, and every matter coming within the legitimate purview of the original action, both in respect of the matters of claim or defense. The principle underlying explanation 4 is that where the parties have had an opportunity of controverting a matter, that should be taken to be the same thing as if the matter had been actually controverted in this. But the principle is very clear. The second repetition would not even have been entertained otherwise. Now, my lord, another aspect of law was not even brought to your lordship's notice, that it is a settled proposition of law that a writ petition claiming merely interest is not even maintained. I am not troubling your lordship at this stage with this judgment. Your lordship may just record my submission, and a writ petition with a mere claim of interest is not even maintainable. This has been laid down by the Supreme Court long back. 1998, Volume 3, SCC 501. 1998, Volume 3, SCC 501, Paragraph 8. No. I am not troubling your lordship unnecessarily. I can take it up in the final hearing also. I'm just indicating my broad contours. Now, one of the questions that might come from the opposite side is of course, there are some facts which were not brought to your lordship's notice, but there are also some questions of law. In a review jurisdiction, your lordship will not go into these questions of law. On that matter, my respectful submission, in the event that submission comes, the law has been laid down very clearly by the Supreme Court. The review as exercised by the civil courts, review jurisdiction, and the review jurisdiction as exercised by your lordship under Article 250 is vastly different. Because a high court is a court of records. When your lordship is exercising jurisdiction under Article 226, it is exercising jurisdiction as a court of records. And Supreme Court has time and again held that since it is a court of records, and these records will be maintained forever in perpetuity, therefore it is a duty of a 226 court to maintain the records correctly. And on occasions, if an error apparent has occurred on account of some erroneous law or non-consideration of law, even then your lordships have the power to exercise your lordship's jurisdiction. On these broad contours, my lord, I am placing 2-3 judgments. One of them is, my lord, 2000, Volume 1 SCC 666. This is the famous M.M. Thomas judgment. And the relevant paragraph is paragraph 14 and 17. Paragraph 14, my lord. The High Court as a court of record, as envisaged in Article 215 of the Constitution, must have inherent powers to correct the records.
Yes.
A court of record envelops all such powers whose acts and proceedings are to be enrolled in a perpetual memory and testimony. A court of record is undoubtedly a superior court, which is itself competent to determine the scope of its jurisdiction. The High Court as a court of record, these words may be kindly marked. The High Court as a court of record has a duty to itself to keep all its records correctly and in accordance with law. So it is not merely factual errors apparent on the face of the records. If there is an error on account of laws, your lordships will correct it. Hence, if any apparent error is noticed by the High Court in respect of any orders passed by it, the High Court has not only power, but a duty to correct it. The High Court's power in this regard is plenary, etc., etc. In so and so of this court has recognized the aforesaid superior status of the High Court as a court of plenary jurisdiction, being a court of record. Now, the other judgment on this issue is 1993. This is Nagra judgment. 1993 supplementary 4 SCC 595.
For SCC, page?
1993 supplementary volume 4 SCC 595. Paragraph 18. This again is a 18 and 19 also. Paragraph 18. Justice is a virtue which transcends all barriers. Neither the rules of procedure nor technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone. Rule of stare decisis is adhered for consistency, but it is not as inflexible in administrative law as in public law. Even the law bends before justice. Entire concept of writ jurisdiction exercised by the High Courts is founded on equity and fairness. If the court finds that the order was passed under a mistake and it would not have exercised the jurisdiction but for the erroneous assumption, which in fact did not exist, and its perpetration shall result in miscarriage of justice, then it cannot on any principle be precluded from rectifying the error. Mistake is accepted as a valid reason to recall an order. Difference lies in the nature of the mistake and scope of rectification depending on if it is of fact or law. But the root from which the power flows is the anxiety to avoid injustice. It is either statutory or inherent. The latter is available where the mistake is of the court. In administrative law, the scope is still wider. Technicalities apart, if the court is satisfied of injustice, then it is its constitutional and legal obligation to set it right by recalling its order. And if your lordship kindly skips over to paragraph 19, what review, this is all in the context of 215, article 215. Review literally and even judicially means re-examination or reconsideration. Basic philosophy inherent in it is the universal acceptance of human fallibility. Yet in the realm of law, the courts and even the statutes lean strongly in favor of finality of decision legally and properly made. Exceptions both statutorily and judicially have been carved out to correct accidental mistakes or miscarriage of justice. Now, my lord, on similar lines, there's another judgment, 1995, volume 1 SCC 58. This I wanted to indicate, otherwise the parameters are very clear. We just at times tend to, my lord, when opposing review petitions, we tend to circumscribe the jurisdiction of your lordships by trying to bring it as if it is, your lordship is exercising review powers like a civil court, which is not. I just wanted to indicate one sentence, two sentences from, it's a very, very long paragraph. Again, I won't trouble your lordship. Paragraph 11, it starts at page 64. I'm sorry. Starts something wrong with the page. Yes. Para 64, it starts. If your lordship will kindly turn to page 65. Just above paragraph 12, 2-3 lines I would like to place one. 5 lines from the bottom of paragraph 11, your lordship will find towards the right hand side, your lordship will find a sentence starting, we are therefore. Has my lord got? We are therefore of the opinion that the judgment under review suffers from a manifest error of law, an error apparent on the face of the record, and therefore liable to be reviewed. We are also of the opinion that the interest of law, it is necessary that the said error is rectified. So even when there is an error apparent on a question of law, When your lordship exercises jurisdiction under Article 250, the powers will be available. But besides the factual things that were not placed before your lordship, what it has resulted in is a huge amount of taxpayers' money, 96 crores out of the public exchequer will have to be paid. So therefore, at this stage, my respectful prayer before your lordship is, your lordship will issue notice, and it appears that my learned friend, Mr. Muzumdar, has already entered appearance. So your lordship will issue notice and stay the judgment under review and fix it for hearing.
Want your submission, it will be heard at 2. It's already 1. Or is any, or
Otherwise, my lord, I'll have to make my submissions. Basically, my lord, the document in respect to which the submissions have been elaborately made, that there were 2 documents, one indicating only 44, another indicating 141.
141.
My lord, admittedly, this is a document of August 2021. The certificates based on which this honorable court had ultimately passed the order earlier was of 29/12/2020. So this calculation of 141 was already there in the record of the government, and this is not a forgery as alleged in the writ petition. Same officer has issued 2 documents indicating 2 different things. It is we thought of filing a writ petition, removing the one where the higher amount is indicated. There is no question of forgery. Your document, 2, 3 documents on the basis of which the writ petition was allowed, my lord, are of December 2020. The certificate which has been referred to so as to show that there were 2 different amounts in 2 different documents, and maybe for that matter there is a forgery, is of August 2021, subsequent document. Prior to that, my lord, about 1 year back, your officers have already said that yes, its amount is 141. At this stage, I would like to only, there is no point arguing, because ultimately the matter will have to be heard in detail. We'd like to file a reply also. My only prayer is, my lord, let there not be any interim order. We will not file any contempt, my lord, till now. We will not file any contempt. Let the matter be heard at the earliest. We'll file a reply. Notice we may go, and in fact, we will file our reply. We're not filing any contempt.
2 reasons, my lord, why I'm making this interim prayer. One is that if your lordship does not stay, the interest will go on increasing. Then they will come up with another claim for interest during this period. That is number 1, madam. And number 2, in any case, these are agreements of 2004 to 2006. He filed the writ petition in 2023 or 24. But if he could have waited so long, the balance of convenience is also in our favor that the order is stayed. Prejudice will be caused.
Apart from that, you have admitted the 44 crores.
44 crores chapter is closed, man. We have paid it.
You have paid it.
Long back. That 44 crores chapter is closed. After getting that 44 crores, they started agitating about this interest.
On merit of this review petition, my submission will be, I'll argue in detail, my lord. All these arguments are made as if it is an appeal against an order passed by your lordship. Well, this Honorable Supreme Court, I have got a very recent judgment. I'll just hand over a copy, my lord. Possibly.
Okay, then we'll hear the matter. But the question of interim, what kind of interim here?
Your lordship will stay the order under.
You have some.
What I'm saying is, I'm assuring this court, we are not going to file any appeal. And so far as my submission, my learned friend's submission with regard to my lord accruing of interest is concerned, even if my lordship passes some order, there will be no bearing on the final order to be passed as so far as interest is concerned. So my submission will be, my lord, let there be no interim order, because the entire review petition is based on the fact of certain facts which are on merit. My submission will be, my lord, in the merit of the petition, that in a review petition, these questions cannot be gone into. As a result, my lord, this review petition is liable to be dismissed. I'll make my submission in detail. There are judgments, my lord, starting from 1963, that Sukhdev judgment, how a review petition is to be entertained. They have not come up with the discovery of any new material. There is no new material based on which they are asking for a review. They are arguing only on merit of the case as if it is a rehearing. Supreme Court has cautioned again and again, my lord. It's not a rehearing of the writ petition already disposed of. So in that way, the matter, my submission will be, we'll file a detailed reply, because certain allegations have been made, and notice may go, and I will file a reply, matter may be heard at the earliest. There be no interim order, we will not file any contempt petition. I am issuing this on the court time. So unless we file any contempt petition, they are not going to suffer in any way.
So can I record that you are not going to file it?
Yes. We have instruction from my.
But
I have
I think-
instruction from my learned friend.
We have, I think, prima facie, we have been able to make out a case. That is, and it is a case perhaps for a state. Because all these questions,
No, regarding
rightly or wrongly, he said
regarding
that I
the
cannot.
documents, regarding the two documents, one says 44 crores and another is 141.
That's
It is your documents.
Yes.
I am,
Document-
that is why I said, I am not going any further. If it is my document, they annexed it in the repetition that was withdrawn. Why did you withdraw it? And why did you file a fresh repetition without annexing it?
Writ petition was not withdrawn because of this. I was not there at that stage when I came subsequently after filing of the second writ petition. Even at the time of filing of the second petition, I was not there. My instruction is writ petition was not withdrawn because of these documents. It was withdrawn for a different reason. My lord. There was some technical error in the filing of the petition. That being the position,
Anyway.
Lordship may issue notice.
Issue notice, একটা কাম করো, What's the order? Chamber
Yes.
order. Now, do you want any fix it? That was I'm asking because
Madam,
you are.
I'll be praying for 2 weeks time. Thereafter, we are not aware of the roster. So they
It
can.
may be difficult because it has to come up before your
Before your
lordship.
lordship.
Unless the roster is notified, then.
That is why I cannot pay for the fixed date.
So your lordship may simply say that list it after 2 weeks whenever this bench is available.
Yes.
That will
Yes.
make it.
Yes.
If
that is
necessary,
one
we'll make a
problem.
little adjustment between us.
Or, oh no, I'll be there. Suppose at Guwahati, then it will be difficult. Only person the record will be here. So it will
Yes.
be.
Otherwise, I would have prayed
On
for.
virtual mode, it
meeting
can
them
be
at
hard,
the
but the
principal
question
stage.
again, it will come that record. will be
Yes.
here. So my bench probability of the month of June is not probable because
Not
last
difficulty, man. There's
2 weeks I'm there and
July
thereafter some the interviews and all will be there. So
Yeah.
June to it may be possible. Maybe after vacation maybe.
Well,
Because
I'm just making this prayer as an alternative. My prayer for interim still remains. Well, in case your lordship is of the opinion that your lordship is not granting, in that case, my learned friend's submission may be recorded that he will.
Definitely, that's what I'm just asking.
Madam, I'm making
whether I
this
can
I'm
record
aware
your
of this,
submission
madam.
that you're not going to file any contempt.
Madam, I'm aware of this. My lord, in fact, thought of this aspect because my learned friend is making it. My instruction for my learned friend that I'm giving an assurance that we will not file any contempt in the meantime.
Okay. Okay. Sure.
No.
Question.
Yeah, no.
No, it reached from the bench in the first half. Your matter
Yes.
is reached from the bench in the first half only. No, I'm not, you're not following me. First half. See, you
Yes,
could have
yes.
made, you
Oh,
could have
yes.
made your submission
Yes,
in the
yes.
first half only.
Yes, Your Honor. That's why I was here to just check
Oh,
whether
that
it
was,
was, but
it was
it
not
was
within
already.
my heavy. Then I thought that 3-4 matters are left. So I'll be there by 2. Now, when we consulted on I mean, I have seen the causes, then I come to know that only one matter is left
Yes.
and your withdrawal matter is there. Anyway, why you want to withdraw this one?
Yes, Your Honor, some subsequent development has been taken place.
Subsequent development?
Yes, due to which the subject matter may be different, Your Honor. So that's why.
Withdrawal, you're seeking liberty for?
Liberty to file a fresh, Your Honor.
You're Mr.?
B type Odialos.
B type on the heart, so and so. Otherwise, you are also appearing this one?
Yes,
Okay.
Your Lordship.
As a government advocate?
Yes, for state.
Also hard and so and so, the learned government advocate for the respondent. It is submitted by Mr. Tapadia that there is some subsequent development in the case, in the matter, and hence this subject matter may have changed, and hence as per instructions of the petitioner, he wants to withdraw the same with a liberty to fresh a file. Interlocutory application is where? Have you filed any interlocutory application for withdrawal? No.
No.
Wait for so and so. Allow for you with your liberty to fresh your file. Okay.
Here, your lordship, I need some time to file affidavit, your lordship.
In item number 22.
Yes, your lordship. I received the instructions.
In item number 22, you're for the respondent.
Yes, your lordship. And for 1 to 4, state respondents, 5 is the private respondent.
1 to 4.
1 to 4, yes, I'm for
You
1
are
to 4.
presently 1 to 4.
Yes.
Five is the private respondent.
Yes, yes. Whether steps has been taken or not, your lordship.
The registrar place the postal receipt number and the date of posting of so and so. The counsel for the petitioner, petitioner remain absent on call. From the office note dated 4/4/6/2024, it is seen that the postal track consignment report has already received by the registry, which was which was obtained as per in pursuant to order dated 29/5/2024 in regards to service of notice on respond number 5. MS so the learned advocate, a learned government advocate appearing on behalf of the respond number 1 to 4. Prayed some more time to file their affidavit in opposition. Prayer allowed. List how many days?
3 weeks, your lordship.
3 weeks. List accordingly after 3 weeks, enabling the respondent to file their affidavit in opposition.